This is the Bills Committee on Dutiable Commodities Amendment Bill 2017. This is our first meeting, and it so happened that I am chairing the meeting because at the beginning of the work of the Bills Committee we need to elect a chairman. So nominations, please. Mr. Yu Siwing. Mr. Yu Siwing is nominated. Do you accept the nomination? Yes. Anyone seconds? Right. Any other nominations? If not, then congratulations. Mr. Yu Siwing is returned chairman of the Bills Committee. So over to you. Well, let's see if members would like to elect a deputy chair. If not, then we don't need a deputy chair. Let's invite the administration in. May I welcome the administration to our meeting. Today's bill is about amendment to Cap 109 Dutiable Commodities Ordinance and also Dutiable Commodities Liquor Regulations Cap 109B to prohibit the sale or supply of intoxicating liquor to minors. So would the administration please walk us through the paper? Thank you, Chairman. On the 21st of June 2017, the Food and Health Bureau tabled in the Council Dutiable Commodities Amendment Bill 2017 to regulate the sale or supply of intoxicating liquor to minors in the course of business to protect the health. Since 2000, under the existing liquor licensing system, we have measures to prevent minors from getting their hands on the liquors. According to Regulation 28 of Dutiable Commodities Liquor Regulations Cap 109B, no licensee shall permit any person under the age of 18 to drink any intoxicating liquor on any licensed premises. There is, however, no prohibition on the sale or supply of intoxicating liquor to minors in licensed premises, including supermarkets or convenience stores. And over the years, we understand that the retail sector has been refraining from selling intoxicating liquor to minors on a voluntary basis. However, there are concerns over the effectiveness of such a voluntary measure, and in the community, test buys have been conducted, and it was found that minors have been able to purchase intoxicating liquor in supermarkets and convenience stores without difficulty. In 2013, according to a survey conducted by the Hong Kong University, 43.5% and of primary 4 to 6 students and 62.4% of secondary school students consumed liquor. although the majority of them obtain liquor from adults, 9.9% of primary students, 24% of secondary school students purchased liquor for consumption themselves. And at present, there is no prohibition on the sale or supply of intoxicating liquor to minors through remote means such as email or online purchase. And to plug the existing loophole in the law, the Food and Health Bureau has tabled the amendment bill to amend Cap 109 Dutiable Commodities Ordinance and subsidiary legislation. And our proposal is as follows. We are going to prohibit the sale or supply of intoxicating liquor in the course of business by restricting the sale of intoxicating liquor from in the course of business, and also imposing a requirement to display a sign containing the prescribed notice of the place of sale or supply in face-to-face distributing, prohibiting the sale or supply of intoxicating liquor. And there will also be a requirement of a prescribed notice to receive a declaration of age from the purchaser or recipient for remote distribution. And we conducted briefing sessions during January and April this year to brief stakeholders on our proposal, and we also invited submissions. The majority of the submissions supported the regulatory regime, and some suggested that more communication be made with the trade on the relevant guidelines. And we also briefed the Liquor Licensing Board on the 9th of May 2017, and we also held a second briefing session for the trade. And on the 24th of May 2017, we conducted a briefing session for members of the Wholesale and Retail Task Force, Food Business and Related Services Task Force, and the Task Force on Business Liaison Groups under the BFAC. The majority of them supported the proposal, and some commented on the enforcement and the guidelines. And we also consulted the relevant panel on the 25th of April. The majority of members of the panel supported the proposed legislative amendments, and we welcome comments and questions from members. I'd like to explain to members that according to Rule 83A of the Rules of Procedure, members should disclose any direct or indirect pecuniary interest before speaking on any legislative proposal, so that other members can decide whether the interest would be related to the legislative proposal. And where there is direct and indirect pecuniary interest, before you speak, you should disclose the nature of your interest, and you should refrain from speaking on the subject or moving motions in relation to the subject unless you have disclosed the nature of your interest. Any questions from members? Mr. Peter Shiu. Thank you, Chairman. I represent the wholesale and retail sector. I need to declare that, Chairman. In relation to this bill, in general, my sector supports the bill because I don't think my sector will support selling liquor to minors under the age of 18. However, we need to clarify a few matters for the benefit of our retailers, because for liquor or for beverage with alcohol content exceeding 1.2%, they will be regarded as alcoholic beverage. What about alcohol for cooking? It also exceeds that alcohol content. And also for disinfectant, I don't know whether it falls within this definition as well. That's one point. The other point is, let's say, because you can also have online purchase, and I want to know how the department will decide whether the purchaser is above the age of 18. What is the proof apart from the requirement at the time of placing the order and the collection of goods? So these are the two questions I'd like to put to the department. Dr. Chan, the bill provides that Sale or supply of intoxicating liquor is prohibited. Intoxicating liquor refers to a beverage for human consumption. So, for disinfectant used on the surface of furniture, it is not suitable for human consumption. As for rice wine for cooking, indeed, apart from cooking, it can be consumed directly. So this will be covered by the bill. The second point is about online purchase. We're going to require in the bill that in terms of sale through remote means, the purchaser will be required to make a declaration of age. And in considering the bill, we want to strike a balance. On the one hand, we do not want to create a loophole in the law in the sense that there is no regulation on purchase through remote means, namely over the internet. On the other hand, if for every purchase the purchaser is required to go through a lengthy process to prove his age, then it will be very difficult for both the vendor and the purchaser. It may also involve collection of personal data. So in order to strike a balance, we require the purchaser to declare his age, and after receiving the declaration of age, if there is no reasonable grounds for the vendor to suspect the age, then this will be a defense available to the purchaser, to the seller in the future. So let's take it that there is an online purchase. Will you require the ID card copy be sent for proof, or just a declaration would suffice? Well, a declaration would suffice. The purchaser can declare that he is above the age of 18. All right, so this is sufficient. Let's say you need to physically deliver the goods. At the time when the recipient collects the goods, will you require the ID card be produced? Can I ask a minor to collect the goods? Dr. Chen. Well, it depends on the merits of the case. Let's say in the case of courier service, to require the courier to verify the age of the recipient will be difficult. But let's say if it's a one-stop service, the company can require the staff member to check the age of the recipient, and if necessary, he can call back the company to clarify. Let's say if the father places an order, and then when the goods are delivered to the home, and when the father is not home, what if I ask the child to collect the goods? Then I think the company can contact the person ordering the goods to confirm it. Will you stipulate that in the regulation? Because this will actually happen in reality. But there are maybe different circumstances, and it would be difficult to include all circumstances in the bill. But in the guidelines to be drawn up in the future, I believe that there would be guidance for the sector. But very likely the deliveryman will not be coming from the same company. He may just be a goods van driver. So let's say we have a child at the age of 13, 14, not too young, but you know that he is below 18. Should the deliveryman deliver the goods? Because ultimately the company is criminally liable. So what should they do in such circumstances? Because we're not still in the process of consultation. We're enacting the bill soon. So the trade associations would like to know under what circumstances they will be breaching the law, because this will inevitably happen. And let's say at the time when the order is placed through the internet and no proof of identity is required, just a tick in a box will be needed, then from the sector's point of view, it seems to be quite toothless, because you don't see the real person and you don't require the proof of identity. So coming back to my previous point, how are you going to deal with that?
Dr. Chen, well, it applies not only to online shopping, because some restaurants are also taking or delivering goods to people's homes. Now, if someone, say a child, opens the door and receives a batch of beer, and then this is spotted by the neighbor, maybe the neighbor will report the case. So in that case, will the online company be held criminally liable and be prosecuted? Ms. Yun. Thank you, Mr. Xiu, for your comment and question. We talked about agent. The agent in the bill doesn't include those who are delivering the goods in the course of business, and they are not otherwise involved in the sale or supply. Sometimes the delivery person doesn't know what he is delivering, so we don't want to interfere with the delivery business too much. So if the company or the delivery person suspects that the person ordering the goods may be the child, well, what he needs to do is to call up the person who places the order to confirm. We are really targeting the sale and supply of intoxicating liquor. Now, if the father makes the order, and if we know that the person placing the order is the adult and it's just a child who is opening the door, actually that is not covered under the amendment bill, because we are not dealing with that under the bill. We'll have to look at the actual situation when the legislation commences. Earlier on, we took reference from different surveys. For the minors, now they now normally buy liquor from, say, convenience stores and supermarkets, because they can't consume on licensed premises, and when they consume liquor on the streets, nuisance is caused. So that's the loophole that we want to plug. Now, statistics show us that 60% buy liquor from convenience stores, and around 40% from supermarkets and 40% from grocery stores. So these are the main channels for buying or purchase of liquor. So we are targeting these main sales channels, and we want to regulate them, because we are targeting the face-to-face distribution. And for online shopping, we have certain requirements, and that is to say that they should put up a notice saying that they would not sell liquor to minors, and we also ask the purchaser to make an age declaration. And in the process, there is no reason for the seller to suspect that the buyer is a minor, then that's a defense for the seller. So we try to strike a balance, and this is a more feasible option. Mr. Xiu, Mr. Chow, Mr. Xiu, please wait for the next round. I didn't count the time. 7 minutes. Mr. Chow, please. Thank you, Chairman. I have a question. I have read through the documents prepared by the LegCo, which set out the ins and outs of this legislation, amendment bill, and earlier the panel has discussed this matter as well. Now, as to who should be held criminally liable, then there are some questions in that aspect. The way the bill is written now is that it will regulate the sale and supply of intoxicating liquor in the course of business. Its several points are set out, restricting the sale of intoxicating liquor from vending machines, prohibiting the sale or supply of intoxicating liquor to minors in the course of business. But the panel's papers show us, raises a question of whether is the shop operators or the salesperson will be held criminally liable. I think the public would like to get a clear answer on that. Can you tell me? Second is a comment. Mr. Xu raised a question, and my observation is that there is a defense. There is a defense in relation to remote distribution. The defense now is that if in the case of remote distribution online sale, if the seller has received the age declaration, then that can serve as a defense. So we will not look at the delivery process. Now, personally, the defense in the bill is that if the purchaser can provide a convincing age declaration to the seller, then that's good enough. Because if you have to regulate the delivery process, then that's going to be complicated. And honestly, some purchasers, the adults may order the goods, but maybe the child opens the door for the delivery man, and the child receives the goods. So you shouldn't be holding the people liable, because it's the adults who place the order. So I think that's acceptable. Let's not try to look or regulate the delivery process. And let's not conduct checks on the delivery process, or else we will be creating even more controversies and disputes. So that's one question from me and one comment as well. Ms. Yun. Thank you, Chairman. Thank you, Mr. Chow. You asked about the responsibility or liability, whether it's face-to-face distribution or remote distribution under the bill. Well, it depends on the individual circumstances of the case as to who should be held liable. And we have made clear provisions for the defense. Say if a salesperson sells the liquor to a minor. Now, the defense is that maybe the salesperson has checked the identity card of the buyer, and he believes that he is really over 18 years old. So in that kind of scenario, that kind of responsibility falls on the salesperson. And the bosses may also be liable. Maybe he is not the person who is selling the liquor himself. Maybe the boss is taken to court because of the act of his salesperson. And his defense is that whether he has put enough measures to prevent other people from committing an offense. Say if the boss has given clear guidelines to his staff, and maybe at the cashier there is a good enough reminder to remind the salesperson not to sell liquor to the minors, then this boss has also had defense. So in the bill, these defense provisions have already been provided to both the salesperson and also the shop owners. Now, Mr. Chow has also raised a comment in relation to remote distribution. In relation to 42.4a, if the person has received the declaration to the effect that the other person has reached the age of 18 years and there is no circumstance that causes a person to reasonably suspect that the declaration is false. So if the person has any suspicion, then he can further verify the situation or whether the person is over 18 years old. Well, thank you very much for your explanation. Now, based on what you said, then both the shop owner and the salesperson may be held liable. Well, of course, we will look at the individual circumstances of the case. So it's not the case that just the shop owner will be held liable and that the shop or the salesperson will not be held liable. So from what I heard, both parties may be held liable. So it all depends on the circumstances. So it depends on whether the shop owners have given enough instructions to the shop assistants. If not enough has been done, of course, the shop owner has to be held liable. Say if the shop salesperson has not received any guidelines and from the shop owner, then the shop owner has to be held liable as well. Say whether the shop owner has provided training, whether notices have been put up, then it seems that the owner is cleared of any responsibility, right? Well, it depends on the actual circumstances. That's more or less a broad direction, I would say. Now, after the bill has been passed, I think we should do more public education, especially among the sales people, so that they would not have any misunderstanding, because shop assistants often have the misunderstanding that it will not be them who will be held liable, but rather the shop owners will be held liable. Mr. Porter, for the policy intent, I think it is very clear from the documents. We haven't gone into the detailed provisions yet, but based on what Mr. Chow said, I would like to find out more. You talk about face-to-face distribution and remote distribution. There is a defense for both face-to-face and remote distribution. But in relation to provision of sales and supply, there is no clear distinction between these two kinds of distribution. Now, for delivery, is it considered part of the sale and supply process? Now, if we just focus on sale and supply, now the manufacturer is also indirectly involved in sale and supply, the wholesaler too, and of course the retailer is involved in sale and supply. The delivery person may also involved in sale and supply, because sale and supply comes with a broad definition. Now, there is also the question of directness in remote distribution. Well, which part of the chain we should target? Should we include all these in the offer for sale or what? So that's point number one. And also, on a broader base, I would like to ask, we all understand the harmful effects of alcohol or liquor. And if, say, restaurants, they have to sell liquor, then they have to do it with a license. And now you're making a further step. You are prohibiting the sale, but you don't put in a licensing system. But for many other countries, the sale of liquor must come with a license. How come that we are doing it differently in Hong Kong? If we want to stop minors from drinking alcohol so that they will not be harmed, so in relation to convenience stores, supermarkets, shouldn't a licensing system be put in place? And then by that you will be able to better control the situation, and you can also, if needed, alter the licensing conditions for these venues. Of course, I understand Mr. Peter Shields' stance. He definitely doesn't want to have that. But from the policy intent, I don't see why that's not put in place. Please explain. Now, with regard to the term intoxicating liquor, Can you give a clearer definition to that term? What do you mean by intoxicating liquor? How will people be made intoxicated? Now, people have, different reaction or response to drinking alcohol.
Face-to-face distribution in the bill, we have quite a clear definition. We're referring to face-to-face and also remote transactions. As for face-to-face distribution, sorry to interject, but as I mentioned just now, you refer to these two kinds of sale in the defense, but not in the prohibition of sale or supply. So does it mean that the prohibition is only confined to face-to-face and remote sale, but not other means? In Section 2, interpretation, we have a definition, but not in the defense. Well, it says that for face-to-face distribution, it refers to a person comes into face-to-face contact with the seller or supplier, or an employer agent with a seller or supplier who has the authority to conduct the sale or supply at a place. So face-to-face distribution means that the seller actually meets the purchaser, whereas for remote means it refers to sale or supply of intoxicating liquor other than face-to-face distribution. Sorry, I need to interject you again. I understand your point, but I understand the interpretation. But if you refer to Section 37 of the bill, you refer to prohibition of sale or supply of intoxicating liquor to a minor in the course of business. We understand what in the course of business means. What about sale or supply? You haven't specified whether it refers to face-to-face distribution and remote sale only, because I understand in the defense provision you mention face-to-face distribution and remote means, and you refer to the interpretation in Section 2. However, here you don't specify face-to-face distribution and remote means, and I'm concerned. Can you clarify that? Well, let's say in the process of selling liquor, are you referring to the whole chain, manufacturer, supplier, distributor, retailer, and everybody would be liable? Is that your concern? Yes. But for the defense, it's only available to face-to-face distribution and remote means. If you include the word directly as well, it would be clearer. But otherwise, even delivery of goods would be regarded as part of sale and supply. We can go back and consider the wording, but what we mean is that one circumstance is that I sell to you face-to-face. The other circumstance is without meeting you in person, I sell the liquor to you through remote means. Well, I think after all, it all boils down to the relationship between the seller and the purchaser. As long as there are clear guidelines, it will do. From manufacturer to supplier, distributor, retailer, without anything specified, are you suggesting that ultimately only the retailer will be liable or not for sale of intoxicating liquor to a minor? We can go back and think about it. Business is not our strong suit, so perhaps we're not very familiar with it, but we're not suggesting a full ban on liquor sale. We're only targeting the sale or supply of liquor to minors. Well, at the time, even if a wholesaler sells liquor to a minor, he is conducting the sale in the capacity of a retailer instead of wholesaler. So we're targeting the actual sale of liquor. Well, but perhaps you should think about the word directly. Chairman, I understand that I've used up my time, but this is an important question. Well, perhaps the Permanent Secretary can also give us a brief reply. Well, actually, we took reference from the sale of tobacco, and at present, for sale of cigarettes, we don't impose a licensing system. Well, how about restaurants? You don't need a license to cover the sale of cigarettes to minors at a bar or a restaurant. Not in the case of liquor, and that's the difference. For liquor control, it's not just about the sale of liquor. There are other factors for consideration, such as whether the premises are suitable for the consumption of liquor. What about in Lan Kwai Fong? You have for the public place outside the bars and restaurants, there is no regulation. Now, this bill targets the circumstances you mentioned, because the difference is that after you buy liquor from a convenience store, you can consume it right outside in a public place, but not so in the case of buying liquor from a licensed premises. But the point is, there might be a crowd gathering outside, and we need to consider the fire services regulation and public order, and whether public nuisance would be caused in the middle of the night to the neighborhood. So it's different from retail that we are discussing. Because for retail sale of liquor, the purchaser can consume the liquor right outside the store, or the purchaser can bring it home for consumption. We have some 5,000 liquor licenses, and it is quite a staggering figure. What about overseas experience on the prohibition of sale to minors? You have 5,000 plus licenses. Are you suggesting that you don't want to affect them, and that our protection for minors will be compromised? In other places, well, there are different approaches. For example, there could be a monopolized business. Only a state-owned store can sell liquor, and other jurisdictions may have different kinds of regulations. As far as our regulatory regime is concerned, it is relevant, because in early 2000, when we first introduced the prohibition of sale to minors, at first we received a lot of complaints. But through publicity and public education, we have seen the fewer and fewer such cases. On average, just about 20 cases a year. So we have drawn reference from our local experience to see how we can take this forward. At the same time, we also consider the fact that there is a voluntary regulatory measure in place already. The problem is with the actual operation, because without any legislation enacted, the seller cannot check the ID card. So we have drawn reference from our experience. We consider this an appropriate measure. If we impose a licensing system, of course, there will be a lot of objections, but it's also about striking a balance and on the use of resources. Please wait for your next round. You have spoken at length. Mr. Peter Shiu, I'd like to go back to the point about sale through remote means. If I understand correctly, the delivery person will not be captured by this bill. Whereas if the company delivers the goods itself, then it will be responsible. It will be caught under the bill, and that at the time of delivery, the ID, the age proof will have to be provided. And what the delivery person does is to call and check to fulfill the legal responsibility. But in actual circumstances, say in a convenience store, if somebody buys a bottle of beer, and if that person looks 18 or be slightly below the age of 18, if the salesperson then requires ID proof, if the purchaser rejects, then should he sell? Well, for his protection, he should not sell the liquor. But what if he looks really 18. Well, it's the same arrangement as in cinemas. If the moviegoer refuses to produce his ID card, you can refuse entry. Because it's for your own protection. We already have a voluntary arrangement in place now. So let's say if a cinema operator follows strictly the arrangement, he can refuse entry and then the moviegoer can go somewhere else. Whereas now we have a prescribed notice, and somebody may be looking really young. He may be above the age of 18, and he may still be asked to produce his ID card, and that happens. We're not suggesting that everybody should produce an ID card for purchase of liquor. So we're talking about reasonable suspicion. Now, about the sale of liquor and the sale of cigarette, I want to know whether the same legal requirements apply for the frontline retail staff. Right, for the sale of cigarettes, we also have a provision prohibiting the sale of cigarettes to a person below the age of 18. So for liquor, we are implementing the same arrangement. For our frontline staff, we'll do regular inspection to see whether the prescribed notice is put up, and we also take action on receipt of complaints. If there is a complaint on sale of liquor or cigarettes to a minor, we conduct investigation. Our staff would check whether the buyer of cigarettes looks like somebody below the age of 18. So we consider the buyer as well, and in future we'll take a similar enforcement approach. So for the sale of liquor, I want to know whether the penalty is the same. It's different. For cigarettes, a level 4 fine applies, about $25,000. For sale of liquor, similarly, the person will be subject to a fine of level 5, $50,000. No imprisonment term, right? So the difference is one of $25,000 and $50,000. For cigarettes, have you ever arrested any frontline staff for not following the rules? Do you have figures? I can supplement the information later in relation to sale of cigarette to minors, about the complaint figures and the prosecution figures. But like DS mentioned, the figures are on the decline year by year. In 2010, we received about 100 complaints a year, but in recent years the figure has dropped to a single digit. As of July this year, we have received only 3 cases of complaint, and on average 30 cases would result in a conviction, and the fine ranged from $400 to $500 to $4,000, so on average $2,000. Because the complaint figures have been on a decline, we consider our enforcement effective. For enforcement on the sale of liquor, we'll also draw reference from the cigarettes arrangement. What about the inspection figure? Is it because of the drop in complaints that you have reduced your inspection effort? Our staff would do regular inspection, and we will check whether the prescribed notice is put up, and we also conduct inspection based on complaints. For example, 10 or 8 years ago, we received 100 complaints. Now we received only less than 10 complaints. We consider it effective, because if the measure is not effective, cigarettes will be sold to minors anywhere, and we believe that there would be more complaints received. So for the frontline salesperson, he should exercise his own judgment, and if necessary, he should ask the person to produce his ID card. But perhaps you can judge by the look of the person. If he looks 18, then perhaps the ID card is not necessary. The responsibility then lies with the frontline staff. What about somebody looking really marginally 18? If the shop keeper genuinely believes that the person is of age, then if the person is actually below age, then what should we do? Of course, we look so much older, it's easier to identify. What about the frontline, the shopkeeper? He may be some recent school leaver. He may not have experience to tell.
So, if the buyer looks like he is just about 18, we'll suggest that the shop attendant check the ID card. This is to protect himself. Now, if after the check the buyer is found to be above 18, so the liquor can be sold. And this is really a measure to protect the shop assistant himself. And also our law enforcers will be using more or less the same yardstick as the shop assistants. We would also be looking at whether the buyers look like he or she is 18 years old. So the yardstick of my staff will be more or less the same as the shop attendants, I believe. Well, we support in principle the direction of this bill. There is, however, a difference between selling cigarettes and liquor. Now, usually, a individual male person may buy some cigarettes, but then for buying of liquor, it will usually be a group of purchasers coming to ask for the liquor. So there will be more conflicts in the selling of liquor, especially when these purchasers are more or less drunk, and then if you don't sell them the liquor, they are bound or more prone to create troubles. So for the shop assistants, they will have to bear a greater risk. So as what Mr. Chow said, we should do more public education and publicity. And also for the notices put up at the shops, you should also actually include information on the penalty, and perhaps even include the hotline 999 there. And you should also organize training classes for shop assistants on how they should deal with conflicts. I think that in that aspect it's quite different from the sale of cigarettes. Well, I'd like to thank Mr. Shiu for his comment. The DOH has already started public education. We'll continue with that work, and we will do more publicity and public education. Mr. Bowden Chow. Thank you, Chairman. For convenience stores, I think the situation is easier there. What I'm thinking about is about the bars and the discos. Well, let's imagine this. First, there are many patrons in these venues, and the sales are very busy, and also the environment may not be so maybe darker in a way. So you said that the shop assistants should play safe and you should check their ID card. Then I think it's quite difficult in terms of the actual operation. It's more complex in terms of operation. So, administration, have you heard views in that regard, and how would your advice be for people operating there? Now, later on, we will conduct more public education. For the bartenders working in the bars, they are the people who are actually selling the liquor, and they play an important role. Say many bottles of wine may be sold one night, and they can easily be caught by the law. DS. Under the licensing system, no minors are allowed to consume the alcohol at the bars. So in our consultation, we talked to the liquor sellers and also the bars as well, and they've been actually doing this all along. And if the minors are not allowed to consume alcohol or liquor there, it presumes that no liquor should be sold to them as well. So that's the practice all along. They are not that worried, and conversely, they have asked us to urgently deal with the issue of sale of liquor at retail stores. Mr. Porter, I would like to respond to Mr. Holden Child's question. We are already having some kind of regulation under Chapter 109B. Now, coming back to my earlier question, how come that the bars should operate with a license, but then people selling liquor on the streets are not required to get a license? Say, if in a bar we try to separate them into two parts, one is for people to consume alcohol, the other part is for sale of liquor. So that means that the parts for selling of liquor, it doesn't need to obtain a license, right? So you are restricting the venues where people can consume alcohol or liquor. And that's not fair to the bars, because they ask people, they allow people to consume liquor on their venues, and they come under stricter regulations. And for the retail stores, they don't need a license, and so you are more lenient to them. So are you being unfair to the bars? Is there a loophole? So that's number one. Number two, also, can you respond to my question on the definition of intoxicating liquor? Number three, in relation to 37 or 35 in part 5, place, you define it as a licensed premises. But does it include all the licensed bars, but does not include an aircraft or a train? If I understand it correctly, that has to do with a subsequent paragraph or provision on display of prescribed notice, and the term place is used in that provision. So can I ask that whether the bill covers all the bars, and that is they are required to put up a sign with the prescribed notice. Now, apart from bars being licensed premises, are there any other kind of licensed premises? The terms seem to be too loose to them, to me. Licensed premises are premises with a liquor license. Now, as to the definition of intoxicating liquor, in 109 there is already a definition. Is in 53C. Intoxicating liquor includes spirits, liquors, wine, beer, and other wine suitable for consumption. And in the same part later on, spirits and wines, there are definitions, and that includes the alcohol or liquor with an alcohol content of over 1.2%. So Mr. Paul is right in pointing out people have different sort of a reaction to alcohol and liquor. So anyway, we have got an objective set of standards, and this is the definition adopted all along. Well, I'm sorry, I don't have an iPad with me, so I'm sure that your definition is right. I have a question of a 3.1. Say if there is some liquor or alcohol in chocolates, so what's your policy objective? Does it include or cover those kinds of chocolates? Okay, let me read the definition in its entirety as well. It doesn't include any products which have as ingredients as the with alcohol. So we are just following the approach already enshrined in the Dutiable Commodities liquor ordinance, and doesn't cover, say, cakes and chocolates with an alcohol content. What about plays? We will look at the present situation and what is the scenario that we want to tackle. Why do we have a liquor licensing system? The liquor license system regulates premises which allow people to consume liquor there. So that's why we have a liquor licensing system, or we have to look at whether the venues can accommodate are suitable venues for people to gather, and we have safety concerns and so on, and the requirements are very strict too. So if we talk about a retail scenario, should we be applying the same set of standards in order to achieve our regulatory objectives? As an administrator, we have considered what is the most reasonable approach. We want to achieve our objectives at the same time. We don't want to interfere unreasonably the business operation. So that's the approach adopted in the sale of tobacco, and we are not having a licensing system in place, and we also do public education on that. So the overriding principle is that since we've got some voluntary scheme in place already, not selling liquor to minors, so that's why we think that our approach is reasonable. We model after the approach for sale of tobacco. And so if we go by a licensing system, that would be more complicated because we have to review the licensing conditions from time to time. And we are now targeting the retail outlets, retail stores which are selling a number of commodities, including liquor. So that's why we are proposing the approach which can plug the loopholes quicker, and also it's a more balanced approach. Mr. Peter Shiu, third round. In the UK, in their policy of prohibiting sale of liquor to minors, apart from penalizing the retailers, the minors also have to bear certain responsibility, or else they would take the risk, because if you just impose the responsibility on the frontline shop assistants, then the minors will be encouraged really to buy the liquor. So in Hong Kong, we will be penalizing the minors who willfully break the law, so that they will be deterred from buying liquor. Thank you, Mr. Shiu. We have noticed that there are different practices overseas, but then we still have regard to our own local situation. Indeed, we have the problem of minors drinking alcohol, but the problem in Hong Kong is not as serious as that overseas. So our ultimate objective is to protect our minors, and so we don't have any plan to penalize them for buying alcohol or liquor. But then if they don't cooperate with our law enforcers, and they have clashes with our law enforcers and they disrupt public order, then they would be dealt with in accordance with the law in that kind of situation. From the perspective of protecting the well-being of minors, so far we don't have any plan to penalize minors buying liquor. Well, Chairman, should we be holding a public hearing so that the trade can come to talk to us and we can listen to their views? You want to have a public hearing, right? Yes. Yes, I think we have talked about that before. We have already held public hearing? No. We said that at the panel meeting. We said that we would we should be holding a public hearing. Yes, I think it should be fine. If a member asks for a public hearing to be held and there is no objection, then we will do that. Well, maybe towards the end of the meeting we can have a clear decision. Mr. Porter, I would like to talk about the policy objective and also the feasibility of implementing the bill and whether there are serious loopholes.
No.
Now, for example, there may be food halls in shopping malls. The booths are operated by individual operators. So under the existing policy or the regulation, let's say if I sell liquor from an individual stall, it is regarded as a retail sale. But if I consume the alcohol in the premises, in the food hall, then no liquor license is required. And take another example. If I have one shop with 2 doors, one unit for drinking, another unit for dining, I want to know whether at the policy level whether you have taken this into account. Yes. Thank you, Chairman. Thank you, Mr. Chair. I don't quite understand your point, but are you suggesting that if the operator reckons that the patrons will be consuming alcohol on the premises, then he should apply for a license? Well, let's say if I buy liquor in a booth in a food hall, somebody may be consuming the liquor inside the food hall or outside. What's the difference between that and people gathering outside convenience stores? Well, the vendor may only operate a takeaway business, and at the moment, no liquor license is required. But once the bill is passed, the same arrangement applies to the booth as in a convenience store, because the person should not be allowed to consume liquor outside the in the licensed premises, and if liquor is allowed to be consumed in the premises, then the person should follow the licensing conditions. But I think the difference is that for a food hall there is a clear demarcation, a clear boundary, whereas for the space outside convenience store, the boundary may not be so clear, but it's a common phenomenon that people buy alcohol and drink alcohol outside the convenience store. The boundary is blurred. At the same time, it's not fair to bars with liquor licenses because they need to pay the license fee. I understand the purpose of your proposal. You don't want to encourage drinking of alcohol. I think it's a step in the right direction, but strictly speaking, I don't think that the measure is effective enough, because you cannot tackle the problem of nuisance caused by crowds of drunkards. I don't know, maybe it's not a licensing issue, but is the boundary blurred in your view? Yes. I don't think that there is ambiguity because we are really targeting minors consuming liquor. At the moment, bars do not allow liquor to be consumed by minors on the licensed premises. At the same time, because the minors are not allowed to drink liquor in bars, they turn to convenience stores to buy alcohol next door. So in the future, if even in convenience stores minors are not allowed to buy liquor, they may not gather there. In Lan Kwai Fong at the moment there are there is a good atmosphere for drinking, there are bars nearby, they can just buy liquor from convenience stores and then just gather outside in the area. And that's the situation we see now. If in the future we prohibit the sale of liquor to minors in convenience stores, we can prevent this from happening. But of course, there may still be people above the age of 18 buying liquor from convenience store and consuming liquor outside. At the moment, they are not specifically regulated unless they commit the offense of, say, drink driving and other drinking-related offenses. What we want to target is minors, because they're not allowed entry into bars. They may turn to convenience stores to buy liquor, and it also causes nuisance. For us, the objective is clear. But you may say that in the future, all convenience stores will be banned from selling alcohol, but this will involve a much wider scope and also our real objective, because our objective at the moment is to target minors buying alcohol at the point of sale. I still have some time, and I'd like to follow up on the question of chocolate and other products with alcoholic content. In sections, in clause 37, subclause 3, it says here that if the product is accompanied by intoxicating liquor as a gift, then it's also liquor. Or, according to the definition you read out in relation to liquor, there is a leeway. But here, why is it that you're so strict in that if it is bought as a gift, it will also be caught? Because we do not want to allow sale or supply of intoxicating liquor in the course of business. For intoxicating liquor, there is a clear definition. But what we want to target is the sale of book which is accompanied by intoxicating liquor. I may actually be selling a book that comes with intoxicating liquor, and that is a major loophole. So we want to clarify. We provide that even if the intoxicating liquor is provided to a minor as a gift, if it is done in the course of business, it will still be caught. Whereas for the previous example you mentioned is about, say, one of the ingredients in a cake, and this is not the same. What about samples of wine? For wine samples, if it is given in the course of business, we still don't think that this should be allowed. Say, if you fill in a form and ask for a free wine sample, the operator should still ask for ID age proof. Are there any other questions from members? If not, then Mr. Peter Chiu just now asked for a public hearing to be held to receive deputation's views. In that case, we won't start clause-by-clause scrutiny today. We'll start the scrutiny after the public hearing. Any questions, Mr. Chiu? Is there any urgency in this matter? We want to plug an existing loophole in the law, and we believe that the bill is quite simple. We hope that it can be passed as soon as possible. And we'll be interested to know roughly when the public hearing will be held. Because the council is in summer recess, the public hearing will be held in early October. So it will be about December, right? We hope that it can be passed as soon as possible. Because there has been some time, we have heard requests from the community that this should be regulated, and that is the reason why we've drawn up quite a non-complicated bill so that it can be passed as soon as possible. Just hold the public hearing expeditiously. I think that we already have a consensus on the bill. But to play safe, we should listen to all views. Alright, so the public hearing will be held in early October, and if we have time, we can scrutinize the bill at the time. If not, then at the next meeting. This is tentative, because perhaps after summer break we'll have a better idea about our diaries. So, meeting's adjourned.
我呢個西區嗰個西區批發市場嗰邊係咪你哋？
唔係㗎，food嗰邊㗎。